then we'll move on to internal affairs to discuss their aspect of the investigation. And just to remind folks, we are not here this evening to have any substantive discussion about the merits of the case. It's really just an information gathering meeting to ensure that we have all the information we have. We have an appeal process advisor, thank you very much, Hank Miggins, former committee member, assigned to represent the appellant in this matter. Is the appellant present this evening?
Yes.
Great. And if the search was illegal, would it violate your policy?
I mean, you know, that's a hypothetical. I mean,
but is it one that you can answer because it's a yes or no answer?
Well, I mean, the thing is, what you folks are doing a month now is you're not having a mini motion suppress. Because you're not going to have the officers here on the road. The appellant is not going to be here on the road. You're not going to have the, you know, kind of 2013 Oregon search and seizure law in front of you trying to figure out whether this is correct or not. What you folks, I mean, this is a relatively narrow issue. What you folks have to decide from now is whether Officer A and Officer B followed Bureau protocol, whether they followed 650 on the search issue. And in 650, you know, you folks can read it, and whether the lieutenant findings on that met the criteria in the ordinance. I mean, that's the issue. It's not whether the search was illegal or not legal. I mean, it's whether they followed Bureau policy.
So the question is, if the search was illegal, can an illegal search be within policy?
Well, so the thing is, the search, I mean, you're mixing two areas of law, because as a former criminal investigator, there are a lot of searches that I thought were unconstitutional. So I brought that in front of the court. The officer testifies he thought he was following Bureau policy. The judge says, okay, your search is unconstitutional. The remedy for my client was that that evidence was excluded from the court case. Whether whether somebody's following Bureau policies or not, that doesn't make a difference whether the search is constitutional or not, or whether somebody would have a remedy at federal court if they're going to say that this officer violated my rights. I mean, it's two different things, because we're set up a totally different context at this point. So I mean, that's a hypothetical, because it was in my own personal opinion when I saw this case, and when I got the tip from the anonymous person, I was concerned enough that I forwarded someone, and I've been trying to fast track as much as I can. So I definitely understand the issue, but for 7 CRC members to try to decide whether the search is constitutional or not, I mean, you guys work hard enough as it is for you guys to try to figure that out. I mean, that's a big responsibility that you guys put on yourself. You don't need to do that.
I was going to say not to belabor it, but it's too late, so I'll just continue. So if you look at 650, you look at, you know, they have specific directive definitions defining search, seizure, property search. They have probable cause, and what probable cause means. You have search warrants and exceptions, and in saying as a general rule, searches require a search warrant, but there are exceptions, and there's some discussion about that. And then there's, you know, a variety of member responsibilities, you know, under the particular policy, and how to inventory stuff that's taken. Yeah, that's 650. And so, in my mind, I think you're right. You know, I agree with what you just said, but I think between some of the issues that are being raised, they're being touched on by the Bureau policy, and the finding letter you know, makes a determination that yes, you know, the lieutenant could see, you know, how it was done and judge that, you know, within policy. And so it's our job then, if we so chose, to say with whether in the 2 improper searches allegations under 650, whether or not, you know, we find that to be, you know, a reasonable conclusion. Whether or not any of us chooses to take that up, I think is another issue. But again, looking at the policy that is being highlighted and the finding memo of, what was right, what was within policy, and coming out with the finding. I think that there is some fair game there. To me, it's an open question. Well, to me, it's not an open question. It's one part of the questions that I raised in my mind that I want to sort of pursue during the hearing. But to say that that's these sorts of issues are completely outside the the scope of our review, I don't think is entirely accurate. And I guess I didn't mean to put that at you. I point that more toward my colleague.
So I think the concern that you've heard is that there's a legal issue that the committee would like further information on in order to make this decision. I've tried to make it as succinct and to the point as I can, which is,
does the degree to which the complainant matched or failed to match the description, does that factor into our determination? Can that be a factor that we consider in our determination as to whether the search was proper?
We're not determining. That's not for us to determine.
Well, I think it is, because if that's a factor that the higher-up decision maker failed to consider, then that's something we can consider as to whether he was unreasonable in his decision. Here's, from a practical standpoint, here's why I'm being a big pain about this. Because I know what's going to happen at the appeal next month. And we are going to fracture along this ID issue. And there's folks here that are not going to be able to, there's folks here that are not going to be able to let go of this mismatch, and they're going to, the same way that in that other case, they're going to try to bootstrap that mismatch into violations that occurred during the stop. And I want to know whether that's allowed or not. If that's allowed, go for it. But I don't think it is. And I think we need to hear from someone smarter than me or any of us, like maybe the city attorney, as to whether we can consider it. And otherwise, we're going to end up where we ended up last time. That's my opinion. Now, I'll shut up and leave it alone.
No, I'm perfectly happy with the way things are.
Thanks.
Mr. Yarosh would like information. Others in the committee feel like they have sufficient information and don't need, or want an opinion, sorry, not information or opinion.
Yes.
See, personally, I don't think it's such a terrible thing as on that other case. If people disagree and can't let go of things, because I think you get a clearer picture of the situation, and ultimately we came to the right decision. So I don't think it's a problem.
All right, so I guess Mr. Yarosh is requesting that Mr. Severe relay his request to the city attorney. Mr. Woverl did show up for a previous appeal and answered a legal conundrum for us that at least one member of the group would like some further clarification or an opinion on. Mr. Woverl is free to take us up on that request from Mr. Yarosh or not, but could you please relay that, Mr. Severe?
So is this a CRC request or is this an individual request?
It's only a CRC request if there's a majority vote.
Yes.
There is not a majority.
All right.
I can call it.
All right. So it's been noted by IPR, and we'll get in contact with the individual CRC member.
A little bit different stories from the two officers as to why the bag got searched. And my concern is this difference in appearance going to be something that could go into weighing a quantum of probable cause of search? The bag, or was the search of the bag irrelevant to the initial stop and predicated on subsequent events that occurred after the stop. And if the search, so Rodney's issue that he put down, which was discarded as premature and outside your purview for what you've done, it really is, I guess the threshold question is, well, gosh, why did they search the bag? What was the reason for the search? And if that reason is contained for things exclusively occurring after the initial stop, then what does it matter about the difference in appearance or how close or how far apart? The search was not, the initial stop was based on that, but the initial stop is not the subject of this inquiry. It's the search, the excessive force, and the rudeness. So if there's a way to get it out, let's get it out. If it stays in, let's understand why and what we do with it.
May I speak? Yeah. Okay. So this is kind of cop learn a lot of stuff. This is called this is a Terry stop. They and you can correct me if I'm wrong with this, but the officers receive information that a crime may be committed, and they give it to discretion. The officers, having reasonable suspicion that a crime may have been committed, and spot a person that kind of matches the description, so they go to talk to that person. I buy that. No problem at all. But then, once they make that stop, and that person's not initially not free, then they have to be able to generate their own probable cause to be able to go to this bag, which they don't do. In fact, what one of the officers says is, and a direct quote is, he searched the bag incident to arrest. If you read the file, he says he searched that. So you throw, they asked for consent, which you refused. There was no problem. They didn't rely on probable cause. They didn't rely on a suspicion that there might be a weapon in the bag. The officers noted there might be a weapon in the bag. They were concerned about that, but the officer said in the end, he searched the bag incident to arrest. So, what you have to determine whether the search of the bag was legal or within policy was the arrest legal and within policy.
That's my understanding.
Okay, thank you.
They didn't have a warrant. They had to generate justification for the search without a warrant.
Right.
One of the exceptions is incident to arrest.
Oh, and another exception is exigency. And
But they didn't use that. They said
it doesn't matter what his stated reason was, as long as he would have had a valid reason to search. So the fact that he said incident to arrest doesn't vitiate exigency. And this whole conversation is why my concern is I don't want us a month from now sitting there voting yay or nay based on our personal interpretations of the law. I think we need guidance on this, and maybe that guidance is going to launch a reinvestigation over some of the issues, because maybe they weren't. That's why the idea of holding these readiness hearings is a great idea. Compliment you on it. Does that answer your question, Mr. Constantine?
From what I understand from reading the investigative report and investigation and looking at the findings and even hearing what you folks have discussed tonight, I think everything within the 5 allegations that were actually forwarded on for investigation and findings are enough for you guys to kind of move this on to the next step of things. The subject's appearance, whether that matched or didn't match, I don't think that's part of the CRC appeal, but whether you both have questions about whether the search was proper and whether the lieutenant's findings meet all the objective standards that are there within the ordinance, I think that's enough for CRC to make a decision on this case. I don't really think you folks need to go back and make the decision on whether she matched or, because that's one that wasn't fully investigated, and that's not before you tonight. And I'm not doing that.
So, there we go.
when they see it.
I won't. I will second Mr. Bisson's motion. Discussion? Okay, let's take a roll
Public
call.
before the vote.
It's true, I do. Public comment. Yes, Dan, please.
Thank you. Once again, Dan Hamilton, Portland Cop Watch. I'll get to some procedural stuff at the end of the meeting, but it feels as though one of the things that hasn't been talked about is that the Internal Affairs dismissed out of hand this initial question of whether the stop was proper, and so you can't talk about it, you can't send it back to ask them to investigate it, and that's just a fundamental problem with our entire system. So I'm hoping that there's some way that that question can come up at the appeal hearing if you're not going to send it back now and ask for that to be done. There are several allegations which may or may not have been missed. I didn't read the initial complaint, but it does seem like if officers thought there was a, quote, Hispanic person, Latino person, and took an African-American woman into custody, there could be an allegation of discriminatory racial profiling of some kind. I don't know why that wasn't looked into. In terms of whether or not it was constitutional, your Directive 315.00 says that members are required to conform to and abide by the rules and regulations of the Bureau, ordinances of the city and county, federal laws, and the laws of all states. Members shall not commit any act or fail to perform any act that constitutes a violation of the rules, regulations, blah, blah, blah. So, in other words, if it was unconstitutional, it would, in fact, be a violation of that policy, which apparently wasn't considered by Internal Affairs or the fact finders. Also feels like we were asking about notes from this officer who wasn't on the scene, and that wasn't important, but interviewing somebody who was an ear witness, who, if they were, let's say, not a sighted person, hopefully that person would have been interviewed if there was somebody who was blind on the scene. So I don't see why that's wasn't done. So I'm hoping that you would ask for that interview to happen before you vote to go ahead with an appeal. And of course the city attorney doesn't want to say that an unconstitutional search is necessarily a violation of the policy, because it's their job to defend the city against lawsuit. So this is another example why you need your own attorney, and if there's somewhere you can get that opinion from somebody else, I suggest that's where you look. I think that's all I have for now.
Further public comment? Yes?
Regina Hannon, Portland Cop Watch. One thing that struck me just from reading this brief summary was the area. And allegedly, the mailbox thing was supposed to be over in 77th and Steele. I happen to live in Southeast, so I know some of these streets. The woman obviously did not have a car. She wouldn't be waiting for the bus. It was clear over in Southeast Foster and Steele. So how far do the police go in order to try to find something that they think possibly matches this? You know, would they go as far as the bus stop at the Ross Island Bridge to see, you know, gee, maybe there's somebody that looks briefly like the suspect?
Anything further, Mitch?